Another great panel here to keep this conversation going, breaking all of this down. Back with me, MS Now legal affairs reporter Fallon Gallagher, there outside of the High Court, former ICE Assistant Chief Counsel and Immigration Attorney Veronica Cardenas, and MS Now senior legal reporter Lisa Rubin, and Norm Eisen, Norm's executive chair of Democracy Defenders Fund, which was co-counsel in this case. Fallon, first to you. For people just joining our coverage, take us inside the court's decision and what you're seeing there on the ground.
Yeah, Antonia, the Supreme Court is upholding birthright citizenship, which is a major blow to the president's immigration agenda, and blocking his executive order that he had signed on day one of his second term, seeking to end birthright citizenship for all people whose parents are here either illegally or temporarily. So this is the big loss for the president that we were expecting it to be, but on narrower grounds. We had expected, based on oral arguments, that this was going to be something more like an 8-1 or a 7-2. And this is like more of a 5-4, 6-3 with an asterisk, because Justice Kavanaugh differs from the majority on the grounds here. You have 5 of the justices who are squarely saying that this executive order violates the 14th Amendment. Now you have Justice Kavanaugh who's saying that there might be a statutory way for Congress to change the law to actually end birthright citizenship. And then, of course, you have the 3 justices dissenting there. Now, this is what we expected it to be. This is a loss for the president, and this is upholding something that has been in our society since the Civil War. Of course, this dates back to the 14th Amendment. Post the Civil War, it was strengthened by the Supreme Court in 1898 with their own precedent confirming birthright citizenship, and then codified by Congress. And so this will stay. This is not a surprise, but this is a significant ruling. And if I could just add one thing, I now have a hard copy of the ruling from our producer, Selena, who was inside. And this is one of the biggest rulings that I've ever seen. Usually these are really small packets that are stapled together, and this is bound with like a fabric binding here. This is like a book. So this is really significant. There are 2 big dissents, one from Thomas and one from Alito. Really substantial ruling here today at the court. Antonia?
Lisa, can you give me more on what we're hearing from Justice Clarence Thomas through his dissent here? Just how astonishing some of his argument is.
Astonishing may be the wrong word. I think disappointing may be another word. I mean, it's certainly predictable based on oral argument that Justice Thomas is picking up a thread that Solicitor General John Sauer left for him, which is to say that the citizenship clause of the 14th Amendment was always designed to imbue the children of slaves with citizenship, but was never intended to give citizenship to people who were temporarily in this country, or now the folks that we think of as like birth tourists or undocumented immigrants of any kind. And so Justice Thomas is really drawing a very big distinction, starting with Dred Scott himself, between blacks and the children of what he calls foreign temporary visitors. And let me read to you, if I can, a little bit from his dissent, Antonia, which starts, blacks were entitled to citizenship because they were Americans. They had no other homeland, owed no other allegiance to any foreign power, and were subject to no other authority. They fought and bled in the same battles, gained and gloried in the same victories, and were liable to be called upon to defend America in time of war alongside every other citizen. And there he is quoting writings of Frederick Douglass. But then he goes on to distinguish Black Americans, and specifically the children of slaves, from what he says are the children of foreign temporary visitors. And I'm going to again pick up from his his opinion. Foreign temporary visitors were attached to their home country, lacked similar bonds to this country, and would not be called upon in time of war. Americans, consistent with their settler ethos, believed that citizens were the people who called a place a home. Accordingly, domicile, a person's legal home, played a key role in both state and national citizenship in America. And let me just stop right there. That is the deciding line that John Sauer and the Trump administration laid for the court at oral argument and in all of their briefings. They said that the citizenship clause does not confer citizenship automatically on everyone born in this country. And not only does it carve out a number of exceptions, but that the phrase subject to the jurisdiction of was not throwaway language, but that it was intended to say only people who intended to make the United States their permanent home and were willing to give themselves up to the laws of this land could be those who could confer citizenship upon their children. So here you see Justice Thomas sort of taking the bait, drawing a distinction between Black Americans on one hand and those who he calls the children of temporary foreign visitors on the other. I would say this is a distinction that large swaths of the civil rights movement will not accept. We've already heard from the NAACP today. In anticipation of this ruling, I've been hearing from the NAACP all week. The civil rights community does not draw the distinction that Justice Thomas is drawing for them with respect to the difference between the children of slaves and their descendants and others.
Yeah, no, I mean, there's been decades and decades of history of actually sort of shared projects, conversation,
Correct.
community building between the NAACP and other Black civil rights organizations and Latino organizations and other immigrant rights groups across the United States. So to me, that's no surprise here. But Veronica, I'm curious how you sort of see the language that Thomas is using here and the sort of the division, I guess, he's trying to create between the descendants of slaves and what he's sort of describing as a repurposed political project.
Right, and I think the biggest distinguishing factor for me is the way that they're using this word allegiance, and connecting it to the parents. So when we go back to 1893 and we look at the Wong Kim Ark decision, right, that was a person who was born in the U.S. to Chinese citizens, and in that decision they specifically stated that the parents were citizens of China. Their allegiance was to China. They could never become citizens in the United States because of the Chinese Exclusion Act, which was later rescinded, a very racist law. The same Supreme Court upheld that that child who was born in the United States was subject to the jurisdiction thereof. They didn't read this allegiance factor into the 14th Amendment. And that is the most astonishing thing for me, because when we go to allegiance, how are we going to determine that? A baby who was born in the United States, what allegiance does that baby have? It doesn't speak anything to the parents. And so looking at that and having that be a factor for him, how is that going to be read on later on?
Yeah, I mean, there's one baby I'm thinking of right now, which is actually the leading striker on the men's team playing in the World Cup right now, Folarin Balogun, who is the child of Nigerians who came to the United States from London. He happened to be born in the United States, and he has chosen to play for the United States in the World Cup right now. I'm curious, Norm, what you make of sort of actually that split screen of the reality of what America is and who represents us and who chooses to have allegiance to us, whatever that fraught word may mean, and what you're hearing from Thomas here.
It's a simple distinction that is as old as the American idea, which was aspirational, Antonia, that all of those born here are American citizens. And the majority decision masterfully traces the evolution of that idea. It's what we call old soil. It was brought over in the English common law. It's been expressed by Congress, including in the Civil Rights Act of 1866. Then putting an end to this terrible divisiveness of the Dred Scott decision in the 14th Amendment, adopted by the Supreme Court, Wong Kim Ark case, 1898, reaffirmed by statute. Kavanaugh got that right, even if he's wrong about the Constitution. The Thomas opinion, which is the longest of all of the opinions here, Thomas's dissent, is just plain wrong. There is no such distinction. I myself am the child of a migrant. My father came here. This case was so meaningful for me as co-counsel at Democracy Defenders Fund. Maybe the most meaningful of our over 300 legal matters and cases, but on a winning streak, won the Cook case yesterday. This was so meaningful. My father came as an undocumented migrant at the beginning of World War II to escape tyranny. He earned his citizenship. There is no such thing in the American idea as that distinction that Clarence Thomas is drawing. It's an outlier. It's an afterthought. It's wrong. It will go in the dustbin of history. Fortunately, these five, if you count Kavanaugh, half Kavanaugh, 5.5 justices, got it right. The idea of America is that everyone born here is a citizen, and Donald Trump doesn't get to excise that part of the Constitution with his Sharpie.